Just a little bit of promotion. We have finalized the dates for our regional conferences this year, and you will see the screen in front of you. Changing Minds is the theme of our regional conference, and then it also has the locations and dates for our regional conferences. So more information will be coming out as we have all of the details, the agenda. But you can just keep a look out on the CIP website for additional information. So with that, I'm going to go ahead and turn it over to Matt Lewis, who will get us started.
All right, thanks, Deb. So I guess just to lay out the agenda for what we're going to talk about here. First, we're just going to go over some basic how a bill becomes a law stuff, and I'm just going to gloss through that, pretty quickly. And I would say that if you want a little bit more in-depth look, we did cover that at a little bit more length in our previous Part 1 webinar that took place at the end of January. So you can go on to our YouTube page and check all that stuff out, and also give you a little bit more of an overview of what was introduced versus what ended up being passed. So just really quickly, the bills are first introduced and then read by title at the time of introduction when the legislature is in session. After that, it goes to reference committee that refers bills to the standing committees that sort of have purview over the subject matter of those bills. In those standing committees, public hearings will be held, and then those will be set for afternoon hearings for those standing committees to look into. After that, if the majority of the standing committee members agree to pass the bill onward, it is then placed on general file. After general file, if it passes the majority of the elected members, it will be advanced to enrollment and review, or ENR, where it will be reviewed for proper form. And then once it is reviewed for ENR, it will be advanced to select file, where changes can be made, and then some of those changes can be approved or rejected. It's again debated on select file, and then can be amended again and then referred back to committee, or indefinitely postponed, or advanced to engrossment at that point. After the bill is or amended, once it goes to engrossment, it's then put into the proper form for final reading, which is just making sure that it's formatted correctly. And then you will have final reading, where each bill is read aloud to all the senators before a vote is taken, and the bill will need a majority of votes, voted elected members, to be adopted into law. At that point, you have the bill sent to the governor's office, who then has the ability to sign it or veto it with objections, and then the legislature has the ability to override that veto. If the bill is signed by the governor or ends up becoming law otherwise, you have 90 days before that bill will end up becoming law, unless there's an E-clause attached to it. So that's just a quick, as you can see from the chart that we have listed up here, there's a couple of different places where it's supposed to fail, and we had a lot of bills that were proposed this year, and seemingly only a handful of things that were related to juvenile justice and child welfare stuff that ended up making its way all the way through. So unless there are any sort of comments that my colleagues would like to make on any of that stuff, I'm going to then jump into talking about some of the juvenile justice bills that were passed, as well as a few of the interim studies and MLRs that were put out related to juvenile justice, and then I'll turn it over to Mary Ann, who will cover some of the child welfare stuff, and then we'll turn it over to the panel and let them sort of weigh in on some of these things. So, so the first thing with the juvenile justice sort of package bill that was 670, it's made up of a couple of different bills that ended up sort of folding all into 670. So if we can advance to the next slide, I think. Oh yeah, and I guess we should take a couple of seconds just to go over really quickly some of the files that we have over here in the bottom right-hand corner of your screen. We've got one chart that is just the bills that passed and some little descriptions and sort of the status of those bills, but we also wanted to include a chart that was all of the stuff that was put up and where it stands, with a little bit of a description, but just to keep it neat and trimmed. We have the passed only We also have a little bit of a breakout on LB 1081, which I think Brian Halstead's going to talk a little bit about. But then I also wanted to include the full text of the final reading copy of LB 670 down in the bottom right-hand corner, just so that you can refer to all the different pages of those things. So feel free to download any of that stuff. So we could flip to the next slide. Okay, so here we just have the pass-only bills that are contained in that one Excel spreadsheet. And the first one up is 670, which if you see the breakout that we have later on in the PowerPoint presentation, I'll just go over this stuff. And I'd like to thank Voices for Children and Julia Summers for helping us get that stuff. But we shamelessly stole it almost word for word and formatted it. So thank you so much for that. So 670 is made up of a couple of different bills with a couple of different changes that are made to the juvenile code, the juvenile justice code, so that, and they were all sort of passed together as a group. So 670 by itself, the bill looks originally at the mandatory membership inclusions, including mandating agency reps, county commissioners, separate juvenile court judges, county court judges, YRTC detention staff, including youth voice on the Coalition for Juvenile Justice, and then also county attorneys, public defenders, and then outlining some of the membership terms of the people that serve on the Coalition for Juvenile Justice. The bill also outlines some of the reporting requirements and mandates for providing guidelines that coalition would have, and it's now included. If you look at the full text of LB 670, it's included around page 32 of the final reading copy. 516 was Senator Penzing Brooks. It changed provisions relating to a report on juvenile facilities. It starts around page 38 of the final reading copy of the new 670 full bill, and it now modifies the definition of room confinement to specifically state that a child must be alone, and it does not matter whether or not the room is subject to video or other electronic monitoring. But this wasn't in the original 516, I believe. I think it was added afterwards, probably in some sort of nod to the confinement bill 870, I think that Penzing Brooks was also putting together. But somebody feel free to correct me on that one later if I've got that wrong. It also provides for the reported data that is put together for reports on juvenile facilities, and as far as it redacts personal identifying information, but it wants to provide individual, not aggregate data of the juveniles that are subject to confinement in juvenile facilities. There's also one last thing. It's an enforcement mechanism. Originally, this was in the original 516 was any person who intentionally or knowingly fails to comply with this section shall be guilty of a Class 5 misdemeanor. The new is just a disciplinary action under 83-4, 134 or 71-1940, which I think deals with some licensing provisions and a couple of other things. So, LB 673 was a cleanup bill of the graduated response bill from last year. It is on page 18 of the new 670 final reading copy, and it's the original language about the revocation of probation. It said that the preliminary hearing to revoke probation could be held before an impartial person other than his or her probation officer or any other person directly involved with the case. This language was struck in favor of language that was more friendly towards the judge that was overseeing the juvenile's case being able to conduct that preliminary hearing before the motion to revoke probation. Next in 670 was LB 774, which was also some cleanup language. It starts around page 3 and goes to page 10 of the larger 670, the full final reading copy, and it goes all the way out to page 10, and it's sort of sprinkled throughout that final copy. And it strikes and cleans up a bunch of on-ramping language in 43-247 that was related to the change of the law for juveniles under 11 that were stopped by police and suspected of offenses that the police officer stopped them for. And that was, I believe that was LB 894 from a couple of sessions ago that created that provision. So it just gets rid of a bunch of the timing provisions for when that law 894 was supposed to take effect. LB 826 also passed, and it provides for jurisdiction to make factual findings under the Uniform Child Custody Jurisdiction and Enforcement Act. It's on page 20 of the 670 final reading copy, and just like it says right there, it allows a court considering initial custody to make factual findings about abuse, neglect, non-viability of reunification, whether removal of to a country of origin would be in the child's best interest. So pretty straightforward. And then lastly, in the 670 large bill is LB 1112, which was Senator Vargas, and it just changes some provisions relating to the placement and detention of juveniles. It starts around page 8 and 9, but then also runs to page 12 and 27 on the final reading copy of 670, and states that a juvenile shall not be detained unless the physical safety of persons in the community would be seriously threatened or detention is necessary to secure the presence of the juvenile at the next hearing as evidenced by a demonstrable record of willful failure to appear at a scheduled court hearing within the last 12 months. So this is just changing the language around the ability to detain kids and trying to make sure that that the kids are actually being detained in response to like a specific and sort of articulable need to detain, rather than just because they don't know what else to do with them, or they're not sure exactly what, where to place the child. So, and then there's also a list of impermissible uses of secure detention that you can see there, and then there's also some community-based aid dollars to allow for to create new alternatives to detention and new detention facilities. So that is 670, and hopefully I just kind of blew through all that stuff. So hopefully some of the people that are on our panel will be able to give that a little bit more of the time that it's due. But that's it in a nutshell. Coming up next is the other bill, which is LB 990, which was Senator Wayne. 990. Okay. LB 990 would prohibit gun possession for people under the age of 25 who've been adjudicated in the juvenile justice system for domestic violence or a felony, and it would make possession of a gun by one of these prohibited persons a Class 3A felony with a penalty of up to 3 years in prison and post-release supervision. Senator Wayne's argument in creating the bill was that more intense services and interventions could be put in place for a juvenile in this situation that was sort of engaging in riskier behavior, and as well as creating a restriction on gun rights that's sort of more comparable to what adults are subject to, as an effort to close the perceived loophole of sorts where some juveniles or young adults with prior records are used by others to possess firearms for them or commit firearm crimes when they're juveniles, knowing that the penalty is quote unquote lighter, or perhaps even maybe make a straw man purchase or something like that later on if they had this juvenile conviction that wasn't able to be found. So, or adjudication that wasn't able to be found. So those prohibited from gun possession could petition a judge to regain their rights, their gun rights earlier than their 25th birthday if their progress in rehabilitation and personal circumstances deemed to warrant that change. So LB 990 also makes exceptions for juvenile offenders who later serve in the military or engage in ROTC or hunting or any one of a number of reasons that you would want them to have a firearm that are a little bit more, I guess, sort of legit. Lastly, in the past bills, and hopefully Mr. Halstead can talk about this a little bit more, is LB 1081, which amends parts of the School Discipline Act to require school boards and principals to review student conduct regulations with the county attorney's office and the conduct that requires a report by the school to law enforcement. So creating sort of a regular yearly dialogue between those groups so that they can review those policies and procedures. Lastly, I'm just going to touch on some of the legislative resolutions and the interim studies that relate to juvenile justice. LR 377 was proposed, I think that was Senator Lowe, that reviews procedures at the YRTCs to improve the safety and security of residents, staff, and the community that surround the YRTCs, so both Geneva and Kearney. It also wants to look at procedures that have been adapted or adopted by the YRTCs that both have worked or have not worked, so looking for a little bit of a report on that, and then reviewing the policies and procedures of facilities outside of the YRTCs that are being used but aren't being utilized at the YRTCs themselves, so successful policies in other facilities. LR 429 looks at school district policies regarding limits on and the use of law enforcement authority in their job duties. I believe this is Senator Penzing Brooks. This includes, yes it was, sorry, I'm reading off my sheet and not looking at the screen, which has her name up there. This includes a look at the number of SROs, the student citation numbers, and the types of charges by SROs. The demographics of the students cited, so race, gender, geographic, where they're coming from, what zip codes. And then looking at national best practice models for trainings and SRO roles, and then a review of Nebraska law on how school resource officers may or may not contribute to the school to prison pipeline. LR 451 it directs the HHS committee to examine the work of the Nebraska Children's Commission and evaluate the need for the commission's continuation and any revisions to its structure and purpose. So it's just sort of a deep dive into the Nebraska Children's Commission and trying to figure out if it's structured the way that it needs to be and whether or not it's sort of meeting the goal and whether or not that needs to continue. So LR 467 will be sort of my last little inclusion here, and it's a review of the delinquency and status offenses and review of neglect cases and then any other pertinent statutes related to the juvenile system. So it seems like it's just a really broad look at the Nebraska Juvenile Code that Senator Wayne put forward. So again, hopefully our panel members can shed a little bit more light on the quick flyby that I'm doing of some of this stuff, but I also want to make sure that I'm giving everybody a little bit of time to talk here. So without taking much more time, I'm going to punt over to Mary Ann Harvey, who's going to talk about child welfare bills.
Great, thanks, Matt. So I'm going to go ahead and start with LB 714, which was Senator Howard's emancipation bill. And we talked more in depth about this on the first webinar, but this provides a mechanism for young people to be emancipated from their parents. And it was signed on April 17th. Some of the requirements include that the minor must be at least 16, living apart from his or her parents, or married. They can file in the district court. They have to serve notice on their parents or legal custodian. And then it provides things that the courts need to consider in making the decision about the emancipation of the minor. So things like whether the minor is able to support him or herself without financial assistance, if the minor is sufficiently mature and knowledgeable to manage his or her affairs, and whether emancipation is in the best interest of the minor. And an addition was that the minor has a commitment to maintaining education, vocational training, or employment as well. The minor in this case has the burden of proof, and so if emancipation is granted, the minor would be allowed to enter into contractual obligations, acquire property, consent to medical, dental, or psychiatric care, enroll in school or college. There's a caveat that the minor has to stay in school in consistency with Nebraska laws, so they can't, if they're emancipated at 16, they can't just drop out of high school at that point. They're allowed to marry and establish their own residence, and they would be individually eligible for public assistance if that's relevant. At the time of emancipation, child support, custody, and parenting time orders would be voided. One important caveat is this does not make the minor an adult for purposes of criminal prosecution. So if there are any delinquency offenses or anything like that, that would still be handled by the juvenile code in the juvenile court. So now I'm going to move on to LB 845, which was signed into law on April 23rd. The bill changed a lot during session, and so basically this bill amended in portions of the bill that provides remedies for family members who are denied visitation, which was a Senator Penzing Brooks bill. And then it just makes a statement that the legislature finds that individuals with disabilities continue to face unfair, preconceived, and unnecessary societal biases, as well as antiquated attitudes regarding their ability to successfully parent their children. And you'll see in the list of legislative resolutions that there are two interim studies related to this bill, LR 459 and 460, which will examine the creation of legislation to ensure that a person is not discriminated against on the basis of disability when it comes to parenting, adoption, guardianship, or foster parenting. And the original bill at the beginning of session was really related to ensuring that custody wasn't denied on the basis of disability, but I think during session it was decided that they needed to do some more investigating before a bill is passed on that. So more to come, I think, on that. The next bill I wanted to mention was LB 998, which was a Senator Walz bill, which would have created a collaborative school behavioral and mental health program. And this bill was passed by the legislature. Unfortunately, it was vetoed after session, so there wasn't a chance for the legislature to override that veto. And I think that the governor's thought on that was that schools could go ahead and enter this collaboration on their own, but there should not be a state mandate that requires them to participate in this. So, and then the last bill that I wanted to talk about was LB 1078, which was signed on April 4th. This bill incorporated much of LB 411, which was a holdover from last session, which is about sibling placement when children are in foster care. And so it requires that DHHS to file a written sibling placement report at every review hearing. It allows all known siblings to the department notice about placement changes for their siblings. It requires the court to make a decision about whether reasonable efforts were made to place children together, even if the siblings have no pre-existing relationship. So for example, if a sibling is adopted by a family and then there's an afterborn child and the older sibling doesn't know this child, but that child comes into foster care, the department would need to make efforts to ensure that those siblings are placed together. The written report has to include reasonable efforts to locate the child's siblings and why the children are not placed together if they're not. And the sibling also has a right to intervene in any, in this case, so in the case of their sibling who's in care, to seek joint sibling placement, visitation, or interaction. LB 1078 also incorporated portions of LB 1073, which requires the foster care review office to maintain a record of relative or kin placements and whether or not those placements were licensed and whether or not the placement received a waiver so that they did not have to be licensed. So in order to track those relative and kinship placements that are happening and whether or not they're licensed, I think that's the intent of that part of the bill. It also requires that a report be made to the Office of Inspector General on allegations of sexual abuse of a state ward or juvenile on probation or in detention or in a group home or in foster care. So ensuring that those reports are made to the Office of Inspector General so that they can be looked into and policy changes or whatever needs to be made can happen to ensure that children are safe when they're in the care of the state. So now I'm going to move on to a couple of the LRs. The first one I wanted to talk about was LR 418, which is Senator Howard. And this is, the purpose of this is to study disproportionality that exists in Nebraska's foster care and juvenile justice systems, especially for youth and families who are Native, African American, or Latino. There's a significantly disproportionate percentage of youth and families of color involved in our child welfare and juvenile justice systems. And this study is to include input from a diverse group of community members of color, including tribes and others whose lives have been affected by the systems, to create an action plan for reducing disproportionality, assessment of a formal body or a task force to lead the work and advise the legislature, DHHS, the Office of Probation Administration, and OJS on policy and practice reform, assessment of current data limitations, so looking at what data is available and what we don't have and why, determination of needs for reporting from DHHS, probation, and OJS to the legislature, review of procedures that may be contributing to disproportionality, research on racial disproportionality within the context of known risk factors like poverty and protective factors, and the availability of community-based prevention services, and then research on model policies that offer a systemic approach to racial disproportionality in foster care and juvenile justice. So this is referred to the Judiciary Committee for a hearing and then a report of findings. So a lot of work to do on that LR, I think, over the summer. But something that's really, I think the systems are currently looking at, and so this is formalizing it and adding required members to the group of people who are working on this issue. The other LR I wanted to point out is LR 430, which is Senator Bowles, and it's to examine the Federal Families First Prevention Services Act of 2017 and its implementation in Nebraska. And that act redirects some of the 4E funding that's available from the federal government to provide some prevention services. And so the LR is to look at how the act is being implemented. It passed federally, and to make sure that its implementation is happening in Nebraska and what all should be included. So the act permits federal funding for prevention services, limits federal funding to children in foster family homes and qualified residential treatment programs and treatment settings for pregnant and parenting teens, youth 18 and older who are preparing for transition, and youth at risk of sex trafficking. It also provides federal investments to kinship navigator programs and reunification services, requires states to review foster licensing standards. States are to track and prevent child maltreatment fatalities. It extends CHAFE funds to former foster youth up to age 23 and education and training vouchers up to age 26. And it would allow for electronic case processing for ICPCs. So the group on this LR will be studying the DHHS state plan and what changes are needing to be made. And that has been referred to the appropriations committee. So that concludes the CIP overview of bills. So we're going to open it up to the panel now. And Jeannie, would you mind starting us off?
Absolutely, and the two major juvenile justice pieces were covered. I just did want to add a couple pieces of clarification. Can everyone hear me okay?
Yeah.
Great, wonderful. On LB 670, Matt talked a little bit about the provisions of that, and I just wanted to clarify this bill does have a few different start dates, and so in the discussion surrounding detention being more restricted for harm to community and those other caveats of, ensuring that detention isn't used as a consequence or a treatment facility or because the parents are refusing to take involvement in their child, those types of things, those pieces actually have a delayed implementation, even though the bill has the emergency clause on it, as Matt alluded to. So those take effect on July 1st, 2019. So we will be looking forward to that, and those came out of, and Juliet may talk a little bit more, some of the statewide work on the Juvenile Detention Alternatives Initiative. So that will be effective there. And then the other provision that goes hand in hand with that is, as Matt discussed a little bit too, is for the community-based aid funding, is to allow one-time use for bricks and mortar, which isn't historically something that has been allowed for that fund, in order to help come up with some other alternatives for some of these populations that we're talking about, that younger population, the parent refusal, the treatment, because I think the biggest piece of feedback we get on that is that there just aren't a lot of alternative placements that exist today. So I would add that. The other piece I wanted to talk about just briefly, and it hasn't been brought up, is overall, I think one of the big things that we talked about in the overview webinar initially was the budget. And so the budget findings that came through were less than were being talked about early on. So there was all of these what ifs. If there's an additional 4% cut, what if there's an additional, what if it looks something different? And so that came back as a 2% cut. And so as I alluded to earlier, and I'm not sure, I think DHHS is in the same position, but we are, and we weren't even looking at cuts to service, cuts to rates, restricting services, those types of things. So The budget information was definitely good news for probation, and we will be able to continue to move forward as we have been. We have been doing a really good job with services and that type of thing, so that will not be an impact to us as we had originally talked about a little bit of an unknown. I think that's it. The other things have been discussed in pretty specifics. We'll be very involved in some of the legislative resolutions that will be happening this summer as well, so we look forward to that.
Great, thank you, Jeannie. So I guess with probation, maybe we can move next to HHS and Sherry Haber. Would you be willing to jump in there?
Sure. Thanks for sharing today, and Marianne covered most of everything that I was going to talk about. LB 1078 really is the one that probably will result in more programmatic instruction to staff. So we'll be working on that and getting that implemented. And then LR 430, I know is going to be a discussion, but our agency has been having those discussions and needs to move forward quickly with decisions on transition planning. And we were just at a conference this last week and met with folks about it, and there's lots of outstanding questions, and we won't have answers before it's implemented probably, but we will be moving forward with what we do have answers to. Encourage anyone who has or is implementing any what they would want to be considered research-based or promising practices, and submit that information to us so that we can get it submitted to the California Clearinghouse and the ACF, because those types of services, if they're approved, can be claimed for 4E matching funds. So we are really interested in trying to get as many things approved as we can that will benefit the children and families that we are working with through the Families First program. So that's where we're at right now.
Okay, great. Well, I guess rounding out some of the agencies, Mr. Halstead, would you be able to go next?
Sure, thank you, Matt. The Department of Education every year puts together a bill full of cleanup matters in state statutes. LB 1081 this last session was the infamous education cleanup bill. The provision that's in LB 1081 that might be of interest to everybody here deals with the Student Disciplinary Code. In 1995, the legislature enacted this Student Disciplinary Act. It applies to all the public school districts in this state, so it's going to cover over 300,000 students each and every year. One provision in that act that they put in place in 1995 was a requirement that any child who is disciplined by a school district under the Student Discipline Act, if that conduct could violate the Nebraska Criminal Code, the principal was required to report that to law enforcement. And that largely stayed in place a little over a year ago at a Coalition for Juvenile Justice meeting. This very statute got brought up and about a need maybe to modify that so that not every violation is getting reported to law enforcement. So what we did was model the language in 1081 after similar language that the legislature enacted earlier this decade that dealt with school attendance and referrals to the county attorney for truancy, to now require going forward annually the county attorney reviews the policy of the school district for the code of conduct of students and what of that code of conduct the county attorney expects to be reported by the principal to law enforcement. So that should narrow and reduce any reporting of students putting them into the juvenile justice system by the principal. It was a rather simple fix that hadn't been done in 22 years, and we think that'll help in some ways. Every year, the county attorney is required under 79-209 to review the attendance policy and how the school district's dealing with children and parents who aren't coming to school, and what provisions are being dealt with by the school district to get kids in school before it's sent to the county attorney for entry into juvenile justice. And the similar process is what is in LB 1081 with relationship to the student disciplinary code. So I'll stop there and let you move on.
Great, thank you very much. We also have Judge Gendler. Judge Gendler, would you be able to jump on next?
Sure. I just have a couple quick comments. I don't want to take up too much time. The first one on LB 1078 regarding the sibling placements, that's a bit of a sea change for us. And there was a recent Supreme Court case in Nebraska from 2016, and I apologize, I cannot pronounce the first name of the case, but it's a 295 Nebraska 324, which was a pretty good discussion on the law at the time, including the fact that siblings don't have standing. I just recently had a case where this was an issue, and I just think we have to be careful now to make sure that we've covered all the bases before we deny a sibling placement, because I think it's pretty clear that we're supposed to look towards that. So this is going to create a whole new battery of case law, and I think a lot of the old things that we were relying on in terms of case law is kind of out the window now. The other one I want to talk about, just Senator Wayne's bill, LB 990. We are still going to be sealing these records, and I'm concerned that some of these kids that come through court may not really understand the ramifications of an adjudication on a felony. We need to put that in our rights advisory, but I suggest as a common practice that when that case is successfully concluded, that child files in juvenile court a request to restore his rights or her rights. Because if we can do that, we probably should, because as they grow older, they're going to forget. And I could see several circumstances where people who are under the age of 25 get pulled over for this and have honestly just forgotten that they had an adjudication in juvenile court, maybe on a felony vandalism or something else that they wouldn't have thought about, but the ramifications are pretty significant. So those are the two things that I wish to highlight right now.
Great, thank you much. And we're leaving our probably best two presenters for last. So I guess Juliet, would you mind going first, and then we'll turn it over to Sarah.
Sure. Can you hear me all right? Oh.
Yep.
Can you guys hear me? Yeah? Was that a yes? Okay. Because I can pick up my phone if I need to. Yeah, okay. All right, cool. Sorry about that. Technology. Yeah, so there were just a couple that I wanted to provide even a little more detail or clarification on after that really great sum up by Matt. Thank you so much. The first was a couple things on LB 670 and the portion of, which was LB 1112 originally. As Jeannie noted, there is that set out date for the changes to the rationale for detention. It's a pretty large change to our statutes governing the uses of detention. So I think the legislative intent in providing that set out date was to give a full year or more to jurisdictions and to courts to identify alternate responses for those cases that currently detention might be being used when it won't be permissible anymore come 2019. And the hope, I think, in linking this to this change to the community-based aid fund is that part of that, part of that jurisdictional assessment of how are we going to treat these cases differently in future is identifying gaps, including now potentially bricks and mortar, and being able to, use some of that funding
try and fill a gap if possible. And then one last piece on it that I don't think anyone raised yet is this final bullet point on this page, but I think is really huge, is that there's also now a specific requirement that jurisdictions, when they're developing their 3-year comprehensive juvenile justice plans, in order to apply for the community-based aid fund, there's now a requirement that racial and ethnic disparities in the system, in the jurisdiction, in juvenile justice be considered as a part of that plan. So that's sort of in line with the interim study that Marianne mentioned regarding racial and ethnic disparity. The data is out there. The data is clear that our systems are producing different outcomes for kids who are coming from different backgrounds and different racial and ethnic heritages. And so the hope is that as we look at that data and really take it at face value for what it means, we can start to do some really comprehensive planning on identifying how we can ensure that our system is serving all kids. So those were my notes on 670 or 1112. And then I also wanted to follow up on what the judge said about LB 990. So this was a bill that we had serious concerns about, in part just philosophically as a basis, that the juvenile court, if you look to the statutory purpose of this statutory civil court, historically it has been entirely rehabilitative when it comes to the youth who is under that court's jurisdiction. Obviously, the judge is, allowed to consider, it's important to consider community safety, et cetera, but the idea and the intent has been a true rehabilitative court to look to the individual youth, what that youth's needs are, and to try to meet those needs to ensure that they no longer recidivate. This bill now adds a true penalty to a juvenile court adjudication that doesn't have necessarily a rehabilitative component to it. And so that's a little different. And I agree absolutely with the judge that both judges and also defense attorneys need to be really careful in these cases to ensure that the youth understands that this penalty attaches and that it has really significant consequences. I would note, I think, as a clarification that a first offense is a class 4 felony if you've been adjudicated and then you're found in possession of a firearm. So first offense is class 4, but then any subsequent offense would be a 3A. Both of those do have prison time as a potential sentence if charged and convicted in a criminal court. I'm not sure. I think Matt said that there may be an exception for hunting. There's not an exception for hunting. It's just military service. And the only way, it's an automatic designation if you're adjudicated in juvenile court on either a felony or a misdemeanor crime of domestic violence. And the only way to avoid that designation, to avoid the possible future penalty, if you're found in possession of a firearm, is, as the judge said, to get that petition. And so another concern that we have is the word used is petition, and there's not currently a statutory jurisdiction in 43 to 47 for a juvenile court judge to hear a new petition to this effect. So we're hopeful that if this were to come up this year, that judges would, have some grace about accepting such a petition, or maybe have it as a motion in the underlying juvenile court case, as Judge Gendler suggested. Otherwise, this potentially could be something that would need to be a piece of cleanup legislation next year. And I also want to highlight as well the issue with sealing, so the sealed record. Our sealed record statute is pretty comprehensive and very clear that once a record is sealed, you can act as if it's never occurred. And obviously this is now an exception to that. So again, falling back on being really careful about warning youth about this penalty that lasts until they're 25 to ensure that they're not, inadvertently caught up in a felony offense down the road. I think that's all for me. Thanks.
All right, and last and certainly not least, Sarah?
Hello, can you hear me okay?
Absolutely.
Okay, thanks for the thumbs up, Juliet. So yeah, being last but not least, that has the challenges of what to add. And I do have a few things to add on it, mostly on the child welfare front. Just I wanted to give a little bit of context for the LD 1078 package. And that is just to say that LD 1078 and then LD 1073 regarding reporting of relative and kinship placements, those were in response to a report released by the Office of Inspector General regarding the sexual abuse of children in care, and I'm sure most people on this call remember that report. I think there were 50 cases, and so what we saw this legislative session was a number of state senators introducing bills to address recommendations from that report and the Inspector General's annual report, I believe, recommendations that were not accepted by HHS or ones that they thought would be helpful to have in legislation. And so LB 1078 and LB 1073 were two of those that made it through, but there were a few others that were introduced in relation to that report and those recommendations that did not advance. But important to note, I think, that those two grew out of those recommendations. And then also on LB 411, the sibling placement bill, I appreciated Judge Gentler's comment. This is a bill that we're really excited about. The reasonable efforts to place siblings together unless contrary to their safety or well-being, of course, was part of the Federal Fostering Connections Act. Senator Campbell had a bill for our state statute several years ago. And this bill really was intended to address, to kind of strengthen that and make sure that the implementation of that federal and state law we're doing well. As Marianne mentioned, one key piece of that was to make sure it applies to all siblings, even if they have no pre-existing relationship. Also in response to, some concerns about implementation in terms of whether across the board we were getting court findings on the reasonable efforts and whether HHS was bringing in the evidence necessary for those findings. And so that's the impetus for the sibling placement report, among other things. And then also just a comment on Judge Gendler's piece about the standing. This does permit specifically siblings to intervene and bring a motion for joint sibling placement, visitation, or other ongoing interaction for that limited purpose, but it does not specify that they have a right to appeal. That was, I believe, in a previous version of the bill that was amended out due to cost, and so I agree very much with Judge Gendler that this changes things, and it'll be interesting to see how it's applied in any case law moving forward. We were able to work with, this is something that young people are always very passionate about, the issue of sibling placement. I think it always ranks one of their top issues, and also Senator Bowles had a constituent that was a foster adopted parent that had an experience that was really passionate about this, so that was great to see. It's also great to see this is a bill, I don't think it was noted, that was introduced last session by Senator Bowles, did not move forward because some of the costs, and Senator Bowles was able to work with the department on some of those issues, as I mentioned. So when bills don't move forward, and you always hear people say maybe they'll move forward next year, and you really don't believe it, this is one of those examples where that did happen and was able to be a part of the LB 1078 package. And then I just wanted to mention also a few things on the LRs. We're also really excited and hope to be working on LR 826, the disproportionality one, and think it's really important, as Juliet and Marianne said, to bring in new stakeholders to that process and affected individuals. And then also just a note on LR 430 regarding the implementation of the Family First Prevention Services Act. I think Marianne gave a great overview. We are actually, Appleseed is helping to coordinate tomorrow. We are having a stakeholder session from 1 to 4. You are all invited. It's not too late. You can email me if you'd like to be a part of it. It's tomorrow in Lincoln. We'll also have a webinar option. I think we can still make that possible if you're interested, from 1 to 4 as part of this interim study to start that conversation about amongst the broader stakeholder community about what the Family First Act means for Nebraska in terms of, as Sherry said, the services. This is a really pretty significant federal shift in federal funding for prevention services, which I think we've all wanted to see for many years, but it'll bring some challenges to Nebraska as well. in addition, some limitations on the use of congregate care. So it's a pretty significant federal reform, means a lot for Nebraska, but as Charity said, a lot of work to do in a short period of time. So our session tomorrow, I'm going to be giving an overview of the federal law. We have some key stakeholders that will be just commenting briefly about their take on implementation and where they're at with it, including Matt Wallen, Deb Van de Griese, and Nick Giuliano from the provider, the CAFCON, and we hope to have some parents and young people as well. If you're interested in that, not to plug too hard, but you can email me, and I'm sure that we'll be having lots of follow-up to that as part of LR 430 in the months ahead. That's all I have, Matt. Thanks.
Okay, great. Does anybody, any of our presenters, have any sort of parting shots that they want to make, or last minute takes on anything that was said? Okay. All right, I think that's a no. Well, this is pretty much it for the webinar. It will be up on our YouTube page probably pretty soon. Tracy's usually pretty quick about putting those up. And again, you can also find part 1 up there if you want to take a look at some of the stuff that was introduced and some of the other descriptions that were up. Our next legislative webinar will be in January 2019, so just wait for that. But also check out our web pages for other webinars and trainings and events. We put those up pretty regularly and try and do these pretty frequently. With that said, also another shout out again about our regional conferences. Please go to our website and look up dates for those and get, we'll be opening up registration for those this summer, so just keep an eye out on that. And if there's nothing else, thank you all very much. If there's any other questions, feel free to email us. Otherwise, have a great week.